Day 1 of the Brendan Dassey trial, State of Wisconsin Circuit Court, Manitowoc County Branch 3, State of Wisconsin Plaintiff versus Brendan R. Dassey Defendant, Jury Trial, Trial Day 1, Case Number 6, CF 88. April 16, 2007, Honorable Jerome L. Fox, Circuit Court Judge. Appearances: Kenneth Kratz, Thomas J. Fallon, Norman A. Gahn, Mark R. Freeman, Raymond L. Edelstein, Brendan R. Dassey. Transcript of proceedings reported by Jennifer K. Howe, RPR, Official Court Reporter. Preliminary jury instructions, opening statements, witnesses: Karen Hallbach, direct examination by Attorney Kratz, cross-examination by Attorney Freeman; Katie Hallbach, direct examination by Attorney Kratz; Thomas Fossbender, direct examination by Attorney Kratz, cross-examination by Attorney Edelstein, redirect examination by Attorney Kratz. Exhibits 1 through 10, 11, 12, 13, 14, 15 through 77, 78. Court will call the case of State of Wisconsin versus Brendan R. Dassey, 06 CF 88. Appearances, please. Attorney Kratz. The state appears by Calumet County District Attorney Ken Kratz. Also appearing is Tom Fallon from the Department of Justice, Norm Gahn from the Milwaukee County DA's office, all appearing as special prosecutors. Attorney Freeman. Attorney Mark Freeman and Attorney Raymond Edelstein appear with Brendan Dassey. The court. At this point, I'd ask the clerk to swear the jury in, please. The clerk. Would the jurors please rise? Please raise your right hands. Jurors sworn. The court. Counsel, I'm going to give you some preliminary instructions for the record. We have previously discussed these, and both sides agree to the instructions to be given today. Is that correct, Mr. Kratz? Attorney Kratz. Yes. The court. Mr. Freeman. Attorney Freeman. Yes, Judge. The court. All right, before the trial begins, there are certain instructions you should better have to understand your functions as a juror and how you should conduct yourself during the trial. Your duty is to decide the case based only on the evidence presented and the law given to you by the court. Do not let any personal feelings of bias or prejudice against any such things as race, religion, national origin, sex, or age affect your deliberations. Do not begin your deliberations and discussions of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. We will stop or recess from time to time during the trial. You may be excused from the courtroom when it is necessary for me to hear legal arguments from the lawyers. If you come in contact with the parties, lawyers, or witnesses, do not speak with them. For their part, the parties, lawyers, and witnesses will not contact or speak with the jurors. Should you be exposed to any reports or communications from any source concerning the case during the trial, you should report that information to the jury bailiff. The court is aware that many of you have been exposed to publicity concerning this case before you were selected to serve as a juror. Each of you has committed to base your verdict only on the evidence introduced during the trial. It is of vital importance to the parties and the sanctity of the court process that you remain true to this commitment. Anything you may see or hear outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received. And third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, jurors, are the judges of the credibility of the witnesses and the weight of the evidence. You are not required to, but you may take notes during the trial, except during the opening statements and closing arguments. The court will provide you with materials. In taking notes, you must be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during deliberations. Otherwise, keep them confidential. Your notes will be collected by the jury bailiff after each day's session and kept in a secure place until the next day of trial. After the trial, the notes will be collected and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You may ask to have specific portions of the testimony read to you. You should pay careful attention to all the testimony, because you must rely primarily on your memory of the evidence and testimony introduced during the trial. To assist you in evaluating the evidence, I will now read to you portions of the specific jury instructions for the offenses with which the defendant is charged. I will read them to you in their entirety at the close of the evidence. Count 1. Count 1 of the information charges the defendant with first-degree intentional homicide as party to a crime, Section 939.05 of the Wisconsin Criminal Code provide that whoever's concerned in the commission of a crime is a party to that crime and may be convicted of that crime although that person did not directly commit it. The state contends that the defendant was concerned in the commission of the crime of first-degree intentional homicide by either directly committing it or by intentionally aiding and abetting the person who directly committed it. If a person intentionally aids and abets the commission of a crime, then that person is guilty of the crime as well as the person who directly committed it. A person intentionally aids and abets the commission of a crime when acting with knowledge or belief that another person is committing or intends to commit a crime. He knowingly either assists the person who commits the crime or is ready and willing to assist, and the person who commits the crime knows of the willingness to assist. To intentionally aid and abet the crime of first-degree intentional homicide, the defendant must know that another person is committing or intends to commit the crime of first-degree intentional homicide and have the purpose to assist the commission of that crime. Before you may find the defendant guilty of first-degree intentional homicide as a party to the crime, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant directly committed the crime of first-degree intentional homicide or intentionally aided and abetted the commission of that crime. All 12 jurors do not have to agree on whether the defendant directly committed the crime of first-degree intentional homicide or aided and abetted the commission of the crime. However, each juror must be convinced beyond a reasonable doubt that the defendant was concerned in the commission of the crime in one of these ways. First-degree intentional homicide, as defined in 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the person, the defendant, guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number 1, Brendan Dassey caused the death of Teresa Halbach or aided and abetted another in causing the death of Teresa Halbach. Cause means that the defendant's acts were a substantial factor in producing the death. Number 2, Brendan Dassey acted with the intent to kill Teresa Halbach, whether he did so directly or aided and abetted another. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not, by itself, establish guilt. You should give it the weight you believe it deserves under all of the circumstances. You're satisfied beyond a reasonable doubt at the conclusion of the trial that the defendant directly committed both elements of first-degree intentional homicide, or that the defendant intentionally aided and abetted the commission of that crime. You should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 2 charges the defendant with mutilating a corpse, also as a party to the crime. Section 939.05 of the Criminal Code of Wisconsin provide that whoever is concerned in the commission of a crime is a party to that crime and may be convicted of that crime, although that person did not directly commit it. The state contends that the defendant was concerned in the commission of the crime of mutilating a corpse by either directly committing it or by intentionally aiding and abetting the person who directly committed it. If a person intentionally aids and abets the commission of a crime, then that person is guilty of the crime as well as the person who directly committed it. Person intentionally aids and abets the commission of a crime when acting with knowledge or belief that another person is committing or intends to commit a crime. He either knowingly assists the person who commits the crime or is ready and willing to assist, and the person who commits the crime knows of the willingness to assist. To intentionally aid and abet the crime of mutilating a corpse, the defendant must know that another person is committing or intends to commit the crime of mutilating a corpse, and have the purpose to assist the commission of that crime. Before you may find the defendant guilty of mutilating a corpse as a party to the crime, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant directly committed the crime of mutilating a corpse or intentionally aided and abetted the commission of that crime. All 12 jurors do not have to agree whether the defendant directly committed the crime of first degree or mutilating a corpse or aided and abetted the commission of the crime. However, each juror must be convinced beyond a reasonable doubt that the defendant was concerned in the commission of the crime in one of those ways. Mutilating a corpse as defined in Section 940.111 of the Criminal Code of Wisconsin is violated by one who mutilates a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number 1, Brendan Dassey mutilated the corpse of Teresa Halbach or aided and abetted another in mutilating the corpse of Teresa Halbach. Number 2, in mutilating the corpse of Teresa Halbach or in aiding and abetting another in mutilating her corpse, Brendan Dassey acted with the intent to conceal the crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find out about intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in the case bearing upon intent. If you are satisfied beyond a reasonable doubt at the conclusion of the trial that Brendan Dassey directly committed both elements of this offense, or that Brendan Dassey directly aided and abetted another in the commission of the crime, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty.